Good morning, everybody, or afternoon. I guess it's morning on the West Coast, and it's now afternoon on the East Coast. Hawaii, I think, is 3 hours behind. So it's 6 a.m. in Hawaii, 9 a.m. Pacific, 12 Eastern. In Europe, I have no idea. Not legal advice. Please like, subscribe, share, comment. Thank you for being here. We're going to discuss the GTII minute order from yesterday in detail. Obviously, this is just opinion. Don't rely upon it. Make your own decisions. This is just for, I can't say entertainment because I can't imagine how entertaining it is, but it's for purposes of just general purposes. Do your own thing. So before we get into the order, and JR was not originally, I thought JR was going to be able to join us today. Maybe on Sunday we will kind of go through it and he can kind of give his take on it. But for today's purposes, it's just going to be little old me, and we'll go through the order. I'll try to see questions when I go like this. I'm kind of looking at to see if I can see questions. But before we do that, of course, wanted to go over a couple of things. I once won a pumpkin carving contest. It was a hollow victory. And I don't even know what this means, but whatever it is, I just thought it was funny. So, a lame duck gathers no moss. I have no idea what that means. I just thought it was funny. And last but not least, I don't know if you guys knew, but in the last election in North Korea, Kim Jong Un got 100% of the vote, and the only other candidate named or else got zero. Anyway, those are my three for today. So we want to talk about the order. So let's clarify this. And just ironically, some it's interesting how things work out. Somebody from another company contacted me today, inquiring about what we did, which I thought was interesting. We collectively did, and second and apart, and I haven't spoken to the person, somebody, a writer from Forbes. This is just funny. I thought this was funny. And I don't think it's related to what we're talking about today. Coincidence, maybe. But a writer from Ford reached out to me today asking about Alpine because he's doing a story on Alpine. And of course, before we went live, I checked the Alpine record to see if the Court of Appeal had finally ruled in DC, and no, they have not ruled. So Alpine is still in the same position. But it was just ironic that I got the two calls. Just interesting. I'll let you guys know what it turns out with Forbes about Alpine, because I thought that was, again, an interesting call. And if the other inquiry turns out to be of interest and I can talk about it, I'll let you know. But so what happened is in or about June 27th in Nevada, a lawsuit was filed. There's about 250 plaintiffs, and it sought a temporary restraining order, receiving an appointment of a receiver to take over control of the day-to-day operations of the business and damages, et cetera. There was a bunch of claims. And there was a bunch of legal maneuvers going on. I think there was a switch of judges. So in courts, in most jurisdictions, if you go and you file a lawsuit, you can change a judge for no reason one time. So I think the original lawsuit was filed. We changed. The other side changed. They then tried to move it to federal court. Apparently, their grounds for moving it to federal court were not sufficient, so they agreed to move it back to state court. A third judge was chosen. That's the judge who ruled on this particular matter. It was within the business court in Nevada, in their district court situation. Yes, that means that's state court system. But they have specialized in Las Vegas. They have a specialized section just for business disputes. I think they have 5 judges. So we went through. This was the third of the 5 that we went to. Um, Eventually, there was a hearing in, I think it was early August. Yeah, would have been early August. There was a hearing, and there were a bunch of papers filed. And at the hearing, which I was monitored in total, so I saw the entirety of it. The judge listened to everything, asked questions, commented, etc. And I've commented before on it because I didn't know how he was going to rule, although I thought he was inclined a particular way. But I thought he was very thorough and he seemed to know what he was doing. I was favorably impressed with him beforehand. And you could check my videos just to make sure that I'm not making that up. So anyway, but I thought he was a good judge. So whether he ruled in our favor or not, took him a couple of weeks to rule, 2.5 weeks. And I was told that he has a very busy schedule. Does a lot of trials. And so I kind of suspected also that if he was going to deny our request, the easiest way to deny a request is just to write a one-word order, and the order would say deny, and that's it. So if you're going to do that, it doesn't take very much time. And I remember I had one case, it's probably like 140 years ago, where I was representing somebody and it was in an injunction proceeding regarding real estate in LA. And we got a temporary restraining order blocking some kind of foreclosure. I represented, I think, commercial landowner or something like that. I don't remember specifically the case, but we went through, and then they had a special division that just heard injunctions, TROs in LA. And LA, that particular courthouse, as it turns out, also is the busiest courthouse in the world, bar none, and literally by stats. And we did about a 2-hour hearing. The judge let me talk probably like an hour and a half, just babbling on. And he would ask me questions and I'd give him answers, and he would seem to be, wow, he really got it. And at the end of the day, I hate that term, but at the end of the day, he, like a week or two later, we got the ruling, and the ruling was deny. One word, nothing, no explanation after 2 hours. So you never know what they're going to do. But the fact that is, if the judge was going to grant the order, it would require a little more work on his part because he'd have to give reasoning for his order. So what would happen is the court would issue minutes and, in essence, issue something called a minute order, which is the order of the court and their findings about the particular ruling. That, and we're going to go through it, that will get translated to a final order and to something called, I think he asked for, findings of fact. So there'll be a document generated that will take what is in the judge's order, will put it into a different format, and that will be the order upon which the receiver will be ordered. And it'll have findings justifying the appointment of the receiver. So that's kind of how it's going to be done. So this is the first step. I presume that and I'll verify it, I presume that our counsel will be drafting now the proposed order. It'll get submitted. The other side might object. They might have clarifications. A judge will make, and this is just generally how it goes. This is common procedure. The judge will look at the objections and will rule one way or another, and we'll get a final order. And once that order is issued, that's the order. And that will be the order appointing the receiver and whatever other relief the final order reflects about that. So that's kind of where we are going. Now I'm going to just talk about the order itself. So, well, let me back up one second. So once the order is granted, and let's say the order is appointing a specific receiver, then that receiver would be appointed, and that receiver will undertake the powers that are given them, including taking over operations of the day-to-day business of the company, which is ultimately what we would like. And if you recall, our goals collectively, our goals were to have this company do some kind of acquisition, generate revenue, to get the board out because they seem to be too old and not willing to do or not able to do the job, and get back whatever. If anything that was done improper, then get back what was done that was improper, if that was the case. And to this date, I think the CEO is no longer with the company. We have now gotten an order appointing the receiver and a TRO, or we will have a final order doing that. And we will have somebody in there, I believe, operating in the best interests of us shareholders, and then hopefully seeking to recoup anything that needs to be recouped. So that's kind of what we're looking at. So now let's look at the order itself. Excuse me. So I'm calling it the order. When I think of the order, I'm thinking of the final order. So we're just now talking about the minute order again. This is the ruling by the judge that will be converted into the final document. So first thing is the judge talks about, and we talked about this, I think JR and I might have spoken about it. I certainly did. The issue was to get 10% of the shareholders together to be able to move forward to get a receiver and TRO based upon a purported breach of fiduciary duty by the officers and directors. Breach of fiduciary duty means that those type of management people have a special obligation to shareholders to watch out for their best interests. And if they don't do that, that's a breach of their obligation owed to shareholders. That may not be a precise legal definition, but basically that's kind of the message. So under the Nevada statute, one of the Nevada statutes, and I guess the one that's most used, if you can get 10% of the collective shareholders of the company together, 10% of the total number of shares, then you can move forward under the statute and try to seek relief. Now, we tried to do that, and we were able to do that. It took us quite some time. We had at least a couple hundred shareholders, more than that. But I know that I probably got contacted by, hundreds, literally hundreds. Some people felt concerned because they didn't want to lock up their shares, et cetera. And this obviously was prior to the second down listing. So I guess if everybody knew about the second down listing, perhaps they may have operated, differently. But we try to get together the number of shares that we could, which we did. But it took a lot of effort. A lot of people contacted. I understand it was a difficult decision. And that's quite a burden. For us, it was something on the order of 38 million, but then they canceled 36 million. So it was based upon 10% of the outstanding shares. It was difficult to ascertain what that number was based upon the financials. And if you recall, also, they had the bogus auditor, Borgers. So is that information accurate? We don't know at this point in time. But we were using, I think, 380 million as the number, which would be on the high side. So that would require 10% of that, which was 38 million. But then if you recall, in June, they returned 36 million shares that were erroneously and inadvertently issued. So that would bring the total down some more. So we got what appeared to be a sufficient number, but that still was challenged at the hearing. But during the hearing, that we also discussed other statutes in Nevada that might provide another way to get a receiver appointed to take over the operations of the company without having to put up 10%. And the reason why I think this is important is because if other companies are incorporated in Nevada and their shareholders believe that they're being taken advantage of, there may be a means for a small group of minority shareholders to come together and find means to influence the company without having to have a great 10% ownership. So the other way that it provides, and this is what the court cited. So the court talks about the 10%, says 10%. That's one way. And that's one of the reasons, one of the grounds, because they proved it up in the declarations. And if you recall, the attorneys that we used, who did a great job, and I did thank them. I tried to provide them as much assistance as I could, but they did a really good job. They really did a good job. But what they did is to prove up 10%, they provided a whole series of declarations from the people that were involved who said, I have X number of shares and I'm going to pledge those shares. and the court found that was sufficient um, to satisfy that statute. But second apart, there's like a catch-all statute in Nevada that says if this was a case in which courts of Nevada have issued a receiver in a prior matter, then it's okay to issue a receiver. And that's irrespective of that 10%. So that could be any case. That theoretically could be one shareholder, although, unlikely. I think the fact that we had a couple, 250 shareholders added support to our claims. But theoretically, in Nevada, if you're in a company and you believe and you can show management has breached their fiduciary duty, I'm no Nevada lawyer, so take it for whatever it's worth. It's just my opinion as a layman sitting here. But if that you could use that catch-all, then that opens the door to a lot of shareholders. And again, you have to have good facts because I think we have good facts here, but it's just another avenue. The other one is the other avenue the court said is if the company is in jeopardy of insolvency, imminent danger of insolvency, or has forfeited the corporate's rights, or has been dissolved or is insolvent, and cited that statute as a section for giving the receivership also. So court cited 3 sections for allowing the receivership. Only one was that 10% ownership. So I think, that opens the door. And what was interesting to me is the section that says that gives the right for a court to issue a receiver in Nevada if it's been done in other cases, means now that this case can be used as a example of a case in Nevada where a receiver was issued per that statute. So if somebody has a situation, they're a shareholder in Nevada, and they believe and they can prove that there's been breach of fiduciary duty, and the situation is similar to what appears to have happened or could have happened in the GTI situation, then they could use this order as evidence of a court in Nevada having previously issued a receivership order which would satisfy the statute. So I think potentially it again may open up the avenue for shareholders who've been aggrieved by bad management to go after that. Okay. The court then adds a fourth. So it gave 3 reasons why to do the receivership. And, part of the court's ruling, the reason why I was very impressed was it's pretty. 1, seems like the judge really got it. 2, I think it's pretty harsh. I mean, it's pretty, I thought, wow, I wouldn't have expected that much of a finding of misconduct. I was really impressed. And I'm going to stop before I go on before number 4, just to state something. So this is just a stage in proceedings. There can be additional proceedings. It may not be the outcome. I just thought this particular ruling and the findings of the court may be very dramatic, but it may be a short-lived victory. So I look at things very short term. For today's purposes, it's great. What happens down the road, and even though I think you will hear the language specifically, even though I think the language is devastating, but it's just a day. It's just a matter. Things can happen. What my recollection is about things can happen is I worked with some friends in Las Vegas, 1988, in a real estate development company. We lived in Vegas for a short time. It was an interesting thing. I had a equity interest in the development company. It was an odd company. I'll just say that at best, an odd company run by odd management, it turned out. And we had an equity interest. And one day, two other people I was with, so three of us. We're sitting in the office, and an appraisal comes in, and based upon the appraisal, I think for that day in 1988, remember 1988, also the year that Kirk Gibson hit his famous home run. I was worth like $5 or $10 million from this one project. 1988, $5 or $10 million was, a decent amount of money. And the other guys who had a lesser percentage also were millionaires. Now we weren't like 100 because we had now been involved with these people. We weren't 100% certain that it was legitimate. But for that one day, we celebrated. The next day, it turned out it was a bogus appraisal, as it turned out. But it made me learn that things can be good for one day, but down the road, let's just take it a day at a time. So this is a really good, I think, opening salvo, and there's been very little, for retail shareholders, there's been very few opportunities for groups of retail shareholders to participate, and very few matters, unfortunately, where we've gotten positive rulings, even though this is interesting because it's against management as opposed to against a hedge fund or something like that. But for what it is, we should celebrate the ruling, but understand it's just a ruling for a day and then move on. So wanted to throw that out. So the fourth reason is the court said we're going to issue the receivership also because it appears that irreparable injury will result and the appointment of the receiver is appropriate even without notice necessary or to interested parties. And if you recall, there was notice because this was done out in June. So it wasn't like the GTII clan didn't know about it. Of course, they knew about it. They were told. There was a discussion. There was a literal discussion because they tried to remove it. There was agreement not to remove it. But there was multiple reasons the court has used to justify appointment of the receivership. My concern was they were only going to use number one. In private discussions, I said with our counsel, I said, I hope they do go beyond that, and they did. So I think that's a great the structure of the ruling is helpful because it can be challenged, of course. But the court has now given multiple bases for justifying the receiver, and the only basis that the GTI crew objected to was at 10%, which still seems to have been met because I guess theoretically they canceled 20 more million shares. The requirement would still be much lower, but because of the other items cited. So we got that. And then the court, that was page one, by the way. And then the court says, so we got that under our belt. Now we got to look at, what do we look at according to the Nevada rules about making the decision now? Now we kind of qualified that they have the right to it. But now kind of in doing our analysis of the issues, what do we look to? So they look at three things. In this case, what's the likelihood of success of plaintiffs, being us, the shareholders? Two, is there any irreparable harm to shareholders, plaintiffs? And three is the balancing of the harm to the defendant versus the public interest. And that's kind of a balancing factor. And the court looks at those three things, and based upon those three categories, makes its decision. So it's already decided that we can do, because of the situation, and four statute that says we can put in a receiver, we can impose a TRO. Then it looks to see, is plaintiff going to win? Are they going to suffer irreparable injury? And let's balance the whole situation, see if what's the most appropriate to see if we can issue a order granting the receivership and a TRO, temporary restraining order. So what did the court do? And now I'm just going to read the next paragraph. I'm going to read slowly, but I thought this was devastating. And this is the court's ruling. And when I saw it yesterday, I thought, wow, and order of events. So I had remember I got sued for defamation by in this case, the defendants, but in my case, the plaintiff, because they claimed my comments about mismanagement, etc., were defamatory. I guess that was the claim. It's kind of hard to decipher, but I think that's the general claim. I thought it was preposterous, and there's plenty of evidence that I think I felt comfortable. But just imagine that claim, and now listen to what the court found on page 2. So I'm just going to read this very slowly. The court finds that regarding the first factor, again, the first factor is whether plaintiff will prevail on the merits. Plaintiffs will likely prevail on their claims against Global Tech Industries, Inc., GTII, current management, defendants David Reichman, Kathy M. Griffin, Frank Benintendo, Donald Gilbert, collectively management, specifically management, 1, grossly mismanaged the company by A, failing to file required disclosures, B, causing the company to be delinquent with the OTC Markets Group, OTC, and Securities and Exchange Commission, SEC, and C, violating security laws and regulations. 2, grossly mismanaged the company by A, filing materially false, misleading, and incomplete disclosures, and B, intentionally omitting material information from its disclosures. 3, grossly mismanaged the company by A, personally enriching themselves at the expense of GTII and its stockholders, B, converting company assets, and C, issuing shares to benefit themselves, family members, friends, affiliates, and other related parties. And 4, put GTI in immediate, imminent danger of being delisted by the OTC or worse, potential regulatory action by the SEC. These facts are supported by the OTC's finding that management has engaged in a continued pattern of fraudulent behavior and material omissions to the public. That's a big paragraph. When I saw that and the findings, that's the findings of the court. That's about as harsh as I've ever seen. I mean, that's not like we just made an error. That is damning. I thought when I read that first paragraph, I thought, just what my thought to myself is, these guys are dead. Management, I'm sure they'll contest it, but this is a court has already made factual findings, and I think these are devastating. And again, I think this stuff is kind of what we've all talked about, all what we sensed, but to have a judge listen to it and get it and make these just, again, all I could say is I think these are devastating findings. Really shocked me in a positive way, but I was still shocked. So that was the first factor. The second factor was whether there's concern that the shareholders will suffer immediate, severe, and irreparable harm, and the court found that too. Especially those who purchase shares in the public markets, they'll suffer immediate, severe, and irreparable harm unless a temporary restraining order is issued to prevent further transfers of GTI shares, prevent further injury to GTI assets, and to prevent further fraudulent disclosures and material omissions by GTI's management team. Finally, regarding the third factor, the court finds that the balance of hardship favors plaintiffs, again, us shareholders. In this case, the balance of the hardship heavily favors plaintiffs. Management has already caused GTII to issue fraudulent financial disclosures, omit material information to the public and shareholders, and cause net operating losses exceeding $96 million over the last 2 years. Management's actions has endangered GTI's ability to continue to raise capital on capital markets, caused it to violate federal laws, and caused it to suffer severe financial losses. Thus, any further transfers or disclosures by GTI pertaining to GTI's assets will result in immediate and irreparable harm to GTI, its shareholders, and uninformed investors. And therefore, based on that, the court issued the ruling appointing the receiver and issuing a restraining order as issued. It ordered our counsel to prepare a detailed order, findings of fact, and conclusions of law based on this particular order that'll be submitted. There may be objections, like I said, but eventually the order will be issued. There has to be a bond, which is typical. So if you come in either for seeking a restraining order injunction or receiver, a bond is required. Here, the required bond is $5,000. That doesn't mean you have to post $5,000. That means you have to post a bond for $5,000. $5,000 would be a low amount typically. You could certainly have a much larger amount. So that's also another step. So what's going to happen from here is, as the court required, our counsel is going to submit and prepare some documents. I'll see it also because they generally show me anything before they file it. We'll get a final our version. We'll submit it. There may be objections, but eventually there'll be a final order. Once that final order is issued, the court will sign off, and the receiver will step in and start taking over operations of GTII. And hopefully the idea, once they take over operations, but I'm way ahead of we're way ahead of ourselves here. But after they take over, the idea would be to clean up the trading status, make whatever management changes are necessary, get a business operating, and pursue recoupment of any particular stock, assets, monies that shouldn't have been distributed that now should be returned. And that's kind of the order of events. So this is great. I thought, I went through the language again, I thought the language of the court was just on point and devastating. Really, I thought it was devastating to GTII management. I think it reflects what went on. I agree with the court's findings about the gross mismanagement, self-dealing, etc., that's reflected in this particular order, the minute order. And to be honest, the language was better than I could have ever hoped for, really. And I appreciate the judge having stepped forward, not being passive, and to reflect what he saw were the problems that existed with GTII. Doesn't guarantee that that everything's going to work out. Does not, unfortunately. But without this, because right now we're in a status where we can't even trade it. So as far as I was concerned, we were dead. There was nothing we could do. So now we are, to me, it appears like the momentum has changed. And I think we are on we have the momentum now. And if we can use that momentum, change the trading structure, clean up the company, generate revenue, get recruitment, then we are back in business. But that remains to be seen. But that's kind of the idea we're looking forward. That will be the idea. So I expect there'll be a bunch of litigation still ongoing as to this language and this document and the filing and all that other stuff. But the findings, again, were devastating. And the findings are the findings. This is what the court has found. What happens, I can't guarantee, but the court has basically just seared GTI management with the multiple claims of gross mismanagement. And by the way, this doesn't even talk about, if you recall, at the hearing, I don't know if you recall because you weren't at the hearing, but at the hearing, the attorney for GTII, when they were asked about that 36 million of shares that was canceled. So what happened was in or about January 25th of 2023, about 65 to 70 million shares approximately were issued by the board to insiders and foundations and other stuff. I don't think there's any justification, or I'm not aware of any justification for that, I would say. And eventually those shares were canceled 18 months later because of they were issued erroneously or inadvertently or whatever nonsense. So it'd be interesting to see, for example, if we're able to recoup those additional shares. If 65 million were issued, but they only returned 36, what about the other 30 or whatever the difference would be? And where are they? And who has the money? Who got paid on those? We also have issues. These are issues because they haven't been answered about why there was a more cash, or why the cash position changed from 22 to 23, about the auditor change, etc. But the judge seemingly got it. We will obviously learn more down the road. And again, I'm really thankful that again, I didn't know how the judge was going to rule, so I prejudged how he had done. But I was impressed, and by his order, he really did get it. And we need more judges like this, that if they see misconduct, they call it out, and they really specify it. And from the grand scheme of things, if his findings of fact, and if this case goes forward and went to trial, and these findings were proven, the defendants would be in great jeopardy, I think, of being liable for punitive damages too, which might potentially wipe them out entirely. Now, I don't know that. I'm speculating, of course, because it doesn't necessarily mean that these findings will hold out all the way. Maybe some will turn out not to be correct. Maybe there'll be additional ones. But if the tenor of the misconduct is proven and the case went to trial, and who knows if it's going to go to trial, most cases don't for all kinds of reasons, I think the defendants would be at risk of punitive damages. And that was certainly not my intention when we got started here. Just to remind everybody, when we got started, we collectively, because I saw myself as an kind of an agent for we just wanted to get a deal done and get rid of management. And we didn't want any trouble with anybody. It's these guys. And I think in an email, or more than one, I sent out to these guys. I said, basically, don't follow the leader here, leading you down the wrong path, at least the way I see it. Get out. And they just could not get out. And I really had hoped, I tried to express that, I really had hoped just for them to kind of get the picture and get out. And I really don't understand really why they did not. Perhaps what the judge found here involves events and facts which go way beyond what is even stated here and might be problematic. I don't know, by the way, that I do not know. But I wish they would have resolved it and we wouldn't have to get to this point where the court literally just skewered them. So I don't know if I have anything else to add to that, but once we get the next document, obviously I'll report when our counsel has the final proposed order, I will go over that. And if there's anything different than what we talked about here, we'll kind of talk about that. If there's any objections filed by the other side, we'll discuss that and we'll discuss where that goes. Once the order is issued, we will talk about the issued order and what the powers of the receiver will be. We might discuss timeframes because I'll try to get more information in terms of kind of what timeframes are. And we'll discuss potentially, appeals, etc. I know that in that catch-all category, that would be tough to appeal. So the 10%, by itself, theoretically, could you appeal? Yeah, but I think that's a tough one too. And, most appeals are lost anyway, unfortunately, or fortunately, depending who you are. But on that catch-all, section where it says in other cases where receivers have been appointed. It's a tough one to win on appeal. And factual findings are important because on appeal, when a court looks, and this is the general rule, there's exceptions, but the general rule is when a court is looking on an appeal, they look at the legal issues. They accept the factual findings of the court as true. So when the court issues devastating, like I'm going to say that as many times as I can, when the court issues devastating factual findings on appeal, those devastating factual findings are part of what the appellate court will consider as the record, and they won't go and look at the facts. So that's why I found these particular factual findings involving grossly mismanagement. It says grossly mismanagement. Actually, it doesn't say grossly mismanagement. It says grossly mismanaged. Violating security laws, filing materially false, misleading, and incomplete disclosures, intentionally omitting material information, grossly mismanaging, personally enriching themselves at the expense of stockholders, converting company assets, issuing shares to benefit themselves, family members, putting GTI in an immediate, imminent danger of being delisted. Again, devastating, and that's what they're stuck with. Anyway, I'm not going to comment how that translates to stock, et cetera, because I have no idea. But in terms of ultimately the business, I think this was the only way we're going to get this to be a legitimate business going forward, that we all can have trust and confidence that it's run by people that have our interests solely at heart. And the court has seemingly agreed with our position. So anyway, I'm going to post this. Obviously, if you have questions or comments, please ask. I'm going to take a quick look to my right. Yes. Somebody asked me this. If it's granted, I don't think they can use any assets. They'd have no access to the bank account. Once the receiver would take over, the receiver would have access to all the operations of the company, the cash flow, the bank accounts, and the receiver would be then reporting to the court. The court manages the receiver. The receiver files, depending on what the court require, would file monthly, quarterly, whatever reports. To the extent the receiver wants to take significant action, they'd have to get the court to sign off on significant action. That would be like, and I'm just guessing, but let's say the receiver wanted, somebody wanted to do an acquisition, and I, by the way, I have no knowledge about that, but just give you an example. Let's say the receiver wanted to do an acquisition. Somebody came in, they were going to bring cash in, and it was a great deal. The receiver then could go to the court and say, we should do this acquisition, something like that. But it might be, buying a hot dog. The court, he might go to the court to buy a hot dog. It doesn't have to be like a huge acquisition. So I'm taking another quick go to my right. Hi, Bill. The receiver has not been appointed yet, so we haven't. Oh, that's a good question, by the way. Thank you. The receiver has not been appointed, but sometimes I bury the lead. But in the minute order of the court, it says management's conduct under NRS 78.6504 is disqualifying the current managers from serving as the receiver. So in their request, I think they had asked Mr. Rabari, to be the receiver. Court is kind of saying that they can't. And what that section is, I'm not a Nevada lawyer, so I can't interpret Nevada statutes, but I think it says that they won't get any priority as potential receivers if they've been negligent or had some type of misconduct. I think that's what that section suggests. And the court, in answer to Billy's question, has said those guys can't be the receivers. So Mr. Rabari could not be the receiver. So if in fact a receiver takes over, if this follows through and the receiver takes over, I think that's entire operation, etc. That's a new company. Um, and again, I'm sure it's going to be fought. Recall, Rabari's already received 8 million shares. I looked at one of the filings, and I don't know. Obviously, I'm not going to say anything obvious, but there may be a situation where the future shares are contested. It may be a situation where the past shares are contested. I don't know if that's my particular issue. I did tell opposing counsel in the defamation action for me apparently accusing management of misconduct, that they had opened the door for me to go after Rabari in that action, because Rabari sued me, even though that wasn't supposed to be the idea. If you recall, or maybe you don't recall, they sued me. They filed an original. They served me with a letter, because I like to repeat this because it was annoying. 6:30 a.m. on a Sunday morning at my house, they served a copy of a letter they emailed to me asking for a retraction based on the comments I had made, claiming apparently that GTII management wasn't doing a good job. So they emailed me a letter. It was addressed to my office, but they didn't send it to my office. What they did is on a Sunday morning at 6:30 a.m., a process server comes and accosts me and hands me a letter. So I was annoyed, to say the least. And then at some point in time, and I had multiple reasons for doing this, but in their filing, in their defamation, so they sent me the letter. The letter basically says, here's 20 statements, and it was, I thought, nonsense, but that was my view. Here's 20 statements. They're defamatory, so retract the statements. But they weren't quoted, and it was like, look at this 28-minute video, and find where you say dog ate the cat, and that's defamatory. Of course, I'm exaggerating, but it was really bad. So I sent him a letter. I said, and I gave him 15 different things, including quote the remark, giving me the context, explain it. Just don't say dog ate cat in a 28-minute video, and that's supposed to really constitute something. And instead of explaining it, what they did is they filed a complaint, and they might have then quoted two things, maybe. So they had, and I don't remember. I'm just guesstimating the numbers, but let's say they had 20 statements and two of them had quotes. And I looked at it, and besides, I thought it was a POS, but that's just my view. I then contacted them because I noted they didn't have a jurisdictional paragraph. So they were filing in federal court. To get in federal court, there has to be something called diversity jurisdiction, which means all the plaintiffs and all the defendants have to be from different states. So I'd heard before that David Reichman had mentioned many times and boasted, at least that's what I was told, that he lived at the Beverly Hills Hotel, drove a Bentley, and if you recall in the Las Vegas complaint, upon which this receivership matter came through, he had given apparently, between the two of them, close to like 1.5 million shares to his masseuse and his mechanic. Different people, I believe. I don't believe the mechanic is the masseuse, and I don't believe the masseuse is the mechanic. But apparently, between the two of them, he gave substantially over 1 million shares, which I thought was probably not a good idea to do, because it might be questioned why you'd be giving, like 850,000 shares or whatever the number is to your masseuse, unless they were a really good masseuse. But he was apparently telling everybody he was from the Beverly Hills Hotel, and that's where he resided. So I saw in their filing, they didn't list where he was. They didn't list the basis of jurisdiction. They didn't say he was not in California. So I brought up the point. They contested it. They gave me a declaration that says he's in New York, even though I think he's not. He perhaps is maybe not being 100% accurate there. And so we're now in federal court in Los Angeles. But that's the matter upon which Mr. Rabari came in. So after I told them, you can correct that deficiency, and I'll hold off filing my response. And I had something in mind I was going to file to hopefully terminate the defamation action against me. But I didn't want them to have the opportunity to amend their complaint after I filed the motion. And as a matter of right, you could do it once, right? So they filed their motion. I brought up the jurisdictional issue. I just wanted them to correct that. Then I knew they couldn't also amend without going to court, and it couldn't short circuit my motion. But instead of just amending to correct the jurisdictional paragraph, they added Rabari as a plaintiff, and they made some accusations. Again, I don't understand how they're defamatory, but that's what they did. So they added a few more allegations that are, in my opinion, they're bogus, more bogus nonsense. But that brought Mr. Rabari into the case. Now that he's in a case, before I wouldn't have access to him because he wouldn't be in my jurisdiction, and I couldn't sue him in California. But what they did is currently they put him against me in California, and now I can go after him, or at least have the option of going after him. Perhaps. At least I've thought about it. I told his counsel that yesterday. I said, thank you for opening the door. And, just to let you know, that discussion I had with counsel. So yesterday I had a discussion with their counsel. Same counsel, by the way. So the same counsel is in Nevada that's doing the lawsuit against me here in California. So the conversation I had with them yesterday about dismissing the defamation action, for various reasons, most of which is BS. That was the main reason. But there's a bunch of legal problems. It's privileged. It's anti-SLAPP. So in California, free speech or your First Amendment rights are protected. So if you are sued for basically exercising your rights of free speech, there's a procedure that happens in the beginning of a case. If you establish that first part, then the other side now, the party that's suing, has to establish that they have a likelihood of prevailing on the merits. If they don't prevail, that's called a SLAPP. It's a strategic lawsuit against public participation. I think that's what it stands for. Basically, it's to shut up anybody using their First Amendment rights. So if you establish you're exercising your First Amendment rights on something that's a public issue, how about talking about GTII to investors, for example, then the burden shifts to the other side to show they'd win on the merits. And they'd have to show why, if I said, for example, that they weren't doing a good job, they'd have to show on the merits why they're doing a good job. Now, it might be difficult, I would think, just my thought. When I went through and I talked about it, I guess I might as well talk about it again. The comments by the court that those defendants, including GTII, current management, David Reichman, Kathy Griffin, Frank Benintendi, Donald Gilbert, as referenced in this particular order, specifically management as defined, grossly mismanaged the company. I'm going to do it one more time. We'll do it one more time just to have some fun on the way out. And then I'll leave it at that. I'll say goodbye now. Wish everybody well. I will keep everybody apprised, but I'm just going to reread that paragraph and then the third paragraph, because those two, I really think the judge tells us where it's at. And again, it took me, I read it a few times before I kind of appreciated the extent of what the judge saw here. But here it goes again. The court finds that regarding the first factor, that's about the likelihood of plaintiffs' shareholders to win, plaintiffs will likely prevail on their claims against Global Tech Industries, GTII, current management, defendants David Reichman, Kathy M. Griffin, Frank Benintendi, Donald Gilbert, collectively management. Specifically, management grossly mismanaged the company by A, failing to file required disclosures, B, causing the company to be delinquent with the OTC Markets Group, OTC, and Securities and Exchange Commission, SEC, and C, violating securities laws and regulations. 2, grossly mismanaged the company by A, filing materially false, misleading, and incomplete disclosures, and B, intentionally omitting material information from its disclosures. 3, grossly mismanaged the company by A, personally enriching themselves at the expense of GTII and its stockholders, B, converting company assets, and C, issuing shares to benefit themselves, family members, friends, affiliates, and other related parties, and 4, put GTII in immediate, imminent danger of being delisted by the OTC or worse, potential regulatory action by the SEC. And then skipping a paragraph, going down to the last line, just to kind of fill out the flavor of the court. Finally, regarding the third factor, the court finds the balance of hardship favors plaintiffs. In this case, the balance of the hardships heavily favors plaintiffs. Management has already caused GTII to issue fraudulent financial disclosures, omit material information to the public and shareholders, and cause net operating losses exceeding $96 million over the last 2 years. Management's actions have endangered GTII's ability to continue to raise capital on capital markets, caused it to violate federal laws, and caused it to suffer serious financial losses. Thus, any further transfers or disclosures by GTI pertaining to GTII's assets will result in immediate and irreparable harm to GTI, its shareholders, and uninformed investors. And again, that is harsh, and that's a mic drop. So have a good day. We'll talk soon. Be well. Thought that was a great ruling.